So, wow, this is pretty interesting. So if I haven't read all of it because it's quite long, but I've read some substantial and significant parts of the Hansard dialogue for the Public Order Act 1986. This was in the Margaret Thatcher government. I didn't actually know when I did the stickers for BentCop.biz that have got Boss Hogg from the Dukes of Hazzard. Didn't actually know there was a lord called Hogg, right? This guy actually was called Hogg. Can you believe that? So they actually did the Dukes of Hazzard character Hogg was actually based on a baron. So it was a joke, but I didn't know. I knew that there was the kind of it was some sort of homage, but I thought more Uncle Sam is just like a general homage of some patriotic American general, not an actual person. I thought it was more kind of like a general personification. I didn't actually know there was a Hogg. I had absolutely no idea whatsoever, and I just pulled out for BentCup.biz, and this Hogg was in Thatcher's government. He actually denounced. I think he kind of removed his own title of Viscount or something, but I didn't know that. I just picked that out of the ether, and he was in the government. He actually, Lord Chancellor. This guy, Lord Hailsham of St Marylebone. He was Chancellor. So he was Chancellor under Thatcher. But we've also got this Baron Mackay of Clashfern, who is a lawyer. I think he's still alive now. I might ask the Lady Chief Justice if she'll contact him and question him about the Public Order Act 1986 and the Tumultuous Act, if he's still knocking around. He's 90 odd, but I think he's still with us. There's Baron Wakeham. Baron Wakeham was Chief Whip. And then we've got Lord Havers. The Lord Havers, or Havers, was the Attorney General, as well under Thatcher, right? So they're prominent people. But I think Mackay is just still alive, but he's retired from the House of Lords. But he is, you can speak to him. He's like a living body still. You can ask him questions. There's probably other people still with us who are engaged in that process. But the thing is, so that's just joke. I mean, that's beyond joke. So there are some screenshots here, right? I went through that Hansard, right? They don't mention the Tumultuous Petitioning Act when they're talking about any repeals. They don't mention petitioning either. But one good thing about the Hansard for the Public Order Act 1986 is that if you search it under the term rights, under general rights, there is actually quite a lot. I think it's mentioned 50, 60 times. All these excerpts here, they're all quite relevant to basically public democratic rights. So they are concerned about how this bill is going to affect democratic rights. They use quite a few examples of football matches. I mean, I know you've got Hillsborough and things like that, those type of events. I still think Hillsborough was a setup, just like the burning down of Parliament, that I now believe that was done on purpose, orchestrated probably by the King and Sir Robert Peel, because Peel directed them to go set the fire, going in the first place, the clerk. So, according to the story. So, but it talks about Stonehenge as well on Salisbury Plain and protests on there, referring to them as hippies and kind of worthless. I knew they would always have something. They'd always got a gripe with Stonehenge and, pot-smoking hippies on there. There's definitely a royalist attack on freedom, a vein in there that I've seen myself with police, and I've actually experienced it when I'm there, and from what they're doing to it with the tunnel and so forth. Some of them don't actually like the site. Some do. Some are proud of it, but other ones are opposed generally. And a lot of rights have been taken away from there recently. Now they even try to penetrate the ground with a hole for a big tunnel. They also refer to football matches and generally, but so they are talking in and around political rights in public, particularly in miners' strikes, picketing, and things like that. So they're concerned about, how legislation could infringe on or make curtail rights, and a need to preserve them. But also they're talking about the definitions of what is and is not rioting and rebellious, and what powers should police have or not. But all through it, it's quite clear that they know that there's one point in this where it does refer to a Bill of Rights. Now, one of the people who are talking are all named in there. I won't reel the names off now, but they're contained in these screenshots, right? Some of these characters are ridiculous, and some of them are kind of positive and kind of like genuine. In the voting they do on this bill under the Thatcher government to put it through, it's quite interesting that it's only sort of it's not split exactly like, and between like 1 to 3 or 5 votes, but it's not like 90% to 10% for and against. It's kind of like about 2/3 to 1/3 or something like that. It's something like 200 votes to 100 votes or so. And I think that it changed as well. I think they did different. There looks to be, for the years and nays, they've got different phases for it, I think, by the looks of it. But anyway, so one of the participants in the debate in Hansard, he talks. He says that there is no. He talks as if there was a Bill and some rights, as if there isn't, right? And kind of like is in sort of denial of like underlying institute law and rights. But another one acknowledges it and mentions it. They're all definitely aware that there is this right, but none of them talk about the Tumultuous Petitioning Act. They don't name it by word. They are concerned about what powers the police may or may not have. But again, this is all... It's a very similar situation to Priti Patel's bill, Public Order Act 2023. It is questionable whether they can do what they're doing and whether what they're doing even is applied to people who would actually be invoking officially the right into use, right? But the Tumultuous Act put actual restrictions on petitioning before. The Tumultuous Petitioning Act does put restrictions on petitioning, but before the actual Bill of Rights. And it's insane that the Bill of Rights, 1688, doesn't even completely totally write off the Tumultuous Act. Maybe that's why they got rid of it. But the thing is, it was made before and set out some procedures to go through just for numbers of people. We know from the William Mead and William Penn case that there was already an acknowledgement of Magna Carta and the Petition of Right being applicable to petitioning and granting rights, and for the jury as well, for general legal process. I think it comes down to judgment of the peers through a lawful process. I don't know how that works if a large group of people spontaneously decide that they're going to officially engage in something to Parliament and they all agree by hand or nod and regard that as a lawful due process. You got me there. right? But at least for this bill, they definitely are talking in and around the Bill of Rights as well when they use the word rights and democratic rights. So, but you read it. I mean, it's quite a. I'll put the link to the page, but it goes on forever. It's quite long. I think it meant to have taken 2 hours when it happened. It was a 2-hour debate, but it's very, very long. I've taken these excerpts out, and I think they're like the ones worth mentioning. What I will say is that I still think that these guys are sort of in a way in contempt of Magna Carta and the underlying legal principle. But what I was looking for, I wanted to try find some evidence for the procedure which existed before they repealed this act, and if it had been used, right? They don't disclose it or discuss it, but their conversation and dialogue does gesture or hint, and I think that because they know they're about to repeal the Tumultuous Petitioning Act, and they're talking about the whole subject of public. To be honest, this is probably, unless you were getting them, repealing unless they were going to do something about the right to petition, or actually, really the Tumultuous Petitioning Act and the right to petition, you don't really go too much into petitioning the government for acts of law because it's standing orders. And the main act, actually, that I would say that was used now is the Town and Country Planning Act, without a doubt. The Town and Country Planning Acts, both of them, you can't get any closer to using modern legislation and codified law than those two acts. They are right on the ball. But the Public Order Acts as well, when it comes to people and public assemblies, and not necessarily putting your hand to signing things, but other ways of acting, all those methods are clearly established in the Tumultuous Petition. All those methods are clearly established, set out and described in the Tumultuous Petitioning Act, including it being acknowledged what ways and methods that you can and cannot officially subscribe to such petitions, not necessarily by hand, but by nod or raising the hand and so forth. And also, some of the activities around it. So the Public Order Act is probably the other act that this dialogue. I mean, I haven't read the dialogue for the Town and Country Planning Acts, but I don't need to, because those acts are, they're self-explanatory, and if you understand them, then I don't need to read Hansard for those, because I get it, and it's clear, right? And they're very good acts. I don't really dispute those acts, although there's still some 10% of uncertainty of, isn't the whole act annulled, basically, for using a certain enactment, why only, whatever sections. So they still don't want to play straight, but it's as straight as you can get with them, really. But in this, so they're referring to, like now we've got these injunctions and so forth going off, and the government are trying to find ways to stop protesters other than trying to put new acts through, and it's questionable, whether these acts can be put through or not. Not after the right to petition. You see, the Tumultuous Petitioning Act that put restrictions on was before the right to petition. I don't think you can make any more acts after that, really. And so anyway, so they talk about police being able to get orders, or if police want to try and stop protests or restrict them where they've been given powers, but they're not being given powers all the time. It says that people can apply for these judicial reviews. But I don't like judicial reviews because a lot of people use judicial reviews if they disagree with councils or how something's been put through by a council, if they want to critique it or criticise it. And apparently they can cost quite a lot of money, and you might end up paying for them, and then the council can claim money from their barristers. The thing with democracy is it's meant to go on a vote, It's meant to be like, petitions and elections and, getting things through a councillor, public consultations. It's meant to be on a vote like a jury. Now, if you go to court and you get a jury and you're not being prosecuted, the thing about court is this, right? Whenever you turn up in court, if you're answering to anything, you are in threat and having to defend something, right? So you're not comfortable, you're not relaxed, you're not like, okay, we'll try and do this or that. Like, if you try to claim some money against someone, they're defending. If you lose, all right, you might have to pay their legal costs and so forth. But you're not, you're not going to get prosecuted or anything like that if you were just trying a civil action. The thing with these petitions were supposed to be like, you're just getting it checked, you're getting something evaluated, looked at, right? And, it could have been by 3 justices or larger part of this grand jury, right? Which is like meant to be citizens. So if it's a political cause and it's citizens, that's like a civil thing. It's not like you're not defending anything, and it's like the public involved in it, right? So that is quite a good thing to do. You'd want more of that now in council decisions, like larger part of a grand jury. Let's have that all the time for like building applications and stuff like that. You'd be laughing. McDonald's won't be laughing, because they won't be there. McDonald's would never even exist if you could get larger part of a grand jury deciding on whether they could build a KFC and that, unless they're addicted to them. But I don't think that they've got a lot of them built. Maybe the football ground and cinema and stuff like that. But I think when it comes to like, how does housing developments and preserving the village and like the peace and, things like that, and I think, to be honest, it might even have stopped people from, building too ridiculous, saving things like nice buildings like, schoolhouses or, just like, traditional or iconic buildings that just get completely demolished rather than being reused and things like that. It would have preserved a lot of things like that. So, but they talk about this judicial review, and I'm like, why are they using judicial review? Who gets a judicial review when the police are wanting to break up Extinction Rebellion? I haven't even known, if Extinction, and if the police are wanting to do this or that. I've never noticed Extinction Rebellion or Just Stop Oil or Insulate Britain get a judicial review to challenge the police. Not that I think we should have to pay for it, but so. What I think is that I think through this act, whatever the process was, and I still haven't found out what it is yet, but I'm getting the dialogue between them in Parliament through this. I think that they're referring to. I think that they're kind of gesturing that process. I think it was like a review or something, kind of like a review. Well, judicial is, justice, isn't it? Justice. So we have the term judicial review now, which is meant to, you can get a judicial review of a case, but only really to see if it was, done properly and so forth. I mean, well, you can complain to the Judicial Conduct Investigations Office, but that's not judicial review, is it? But I think that it must have been regarded as something kind of like a judicial review. But then again, I don't think you get a grand jury or part of a grand jury in a judicial review. I think it's just like people employed by the government or whatever, which is kind of really like we want more people. We want juries in civil cases, because then these Rishi Sunak characters can't run off with all the money. The public, but the thing is, Rishi Sunak would never want, the staff of his own factory to rock up in a civil court and then be deciding whether or not, his wife should get £59 billion and he should only get, £1 billion if they split up, because then Rishi Sunak wouldn't like the fact that, the working class people, labour factory workers, would be making the decisions of his money, or even think that he shouldn't have that much money or none of them deserve it, I think this is how these elites, I don't think that they regard us as their peers anymore. I think that, definitely, the elite class, the Warburtons, the Mr. Kiplings, the Bill Gateses, the Elon Musks, they definitely don't regard themselves as, normal citizens like everyone else, and that they should be judged by their citizens, even though it's not like Baron Munchausen or Lord Lucan or whatever, or even the Prime Minister. Well, the Prime Minister, the Right Honourable Prime, at least while he is Prime Minister, they don't think that, working class people should judge rich people because they're not their peers anymore. Although Jeremy Corbyn would probably disagree with that, I hope. I think Jeremy Corbyn hopefully would believe that, maybe Sunak should be judged by a jury, at least, if he wasn't an MP, maybe after he's finished being an MP, he should get judged by a civil jury, But, so, anyway, this is like, I think that there was a process and it was being used. Now, so, therefore, following on from the other video that I just made, which is looking at the actual amendments that they made, which appear in the law, what is puzzling about this whole affair is this, right? In the Act, recorded in the Act, they focus on they claim the reason why they repealed it is that, you no longer need to, you no longer need to have restriction on how many people can present a petition, right? Any number of people can present a petition to either House of Parliament or the monarch. But that is not the first part of the Act. The first part of the Act is definitely about who can subscribe to it and how many people are allowed to agree to it, consent to it, without getting a review of it, right? Now, maybe they thought that there is a possibility that they thought that, if 20 people can do it and you can do it, 20 people can do it without getting some sort of review. I'll use the word judicial review, but, a legal, proper proceedings check. Maybe they thought that, if 20 can do it, why does it matter if more or not, right? But the ironic, this is like the kind of like, in a way, all of their they're kind of like they're debating backwards and forwards over the particulars and the niches in and around, what you can and can't do in large numbers of groups of people, what's intimidation, what isn't, what's aggression, what isn't, what is rioting, or, what is peaceful and what power shouldn't police have, right? And they are debating the legislation and know it might infringe on people's rights, or, it might infringe on people's rights to free speech or protest or gather together. And there's actually one part I really like in it where one of them says something about, what if people want to spontaneously, what if something happens and they need to spontaneously react and exercise their rights? I really like that part because he's acknowledging that you can spontaneously react and invoke the rights there and then and put them to use. And he knows that the democratic and political rights. So that probably is the best piece out of it all. Which is in these screenshots here of the parts that got of it. You just need to go type the search word in rights, and there's about 52 or something, and you just skip through them all and read those parts. Now, the thing is, if this procedure or process was kind of regarded as a judicial review for this Tumultuous Act, if that was the words that kind of compare to it or refer to it, so like if you get over 20 signatures, then the thing is, you would be getting a grand jury, if you wanted to use a grand jury, or 3 justices, check over what you're going to be doing and what it's about, and then get an approval on it. So then you wouldn't ever, you would be sure and certain, and it would be official of your rights when you were out doing political actions, because you had them approved. So then there would be no discrepancy between, who was covered with rights and who wasn't. Okay? And that's the thing. So, but then I suppose, the bit of dialogue that I just referred to, that when I said, what if you run spontaneously, I think really that highlights the William Penn and William Mead case, really, because that's what happened in that case in the 1670, what's on the plaque at the Old Bailey. That was like a spontaneous kind of set of circumstances, and then they ended up going in court. So really, in a way, by abolishing the Tumultuous Petitioning Act, it's almost like that case, really. And that case was supposed to sort everything out, really. But in a way, all this Public Order Act 2023, you see, all that locking on and all that nonsense, all that complete, absolute legislative tosh, which is illogical, non-workable, not practical, and contradictory on every level of the English language, in the practicality of having a bike even and fastening it to something, or fastening your feet onto a bike, right? It just doesn't work. It fails logic of the human mind. If they'd have just had, if we'd have still had that Tumultuous Petitioning Act, right, there wouldn't be any of those problems. None. Because everything would be kind of like being under case management, right, effectively. So you wouldn't have the police getting involved, really. Because if anything you did got challenged, it would be like an election petition, really. It kind of would be an election. It would be like an election petition proceedings if you were getting challenged, really, by the police. And then you'd have the prosecutor there, but then you would be like, okay, what's all this about, And then you would be, the thing is, the courts can't make decisions about legislation, right? Only Parliament can. But I was saying that, why are they hearing the matters of the campaign? What the campaign's about? It's none of their business, right? It was their business before, but they're there to defend a criminal charge. That's the thing. And they're not even acknowledging the rights anyway, really. And when they go in there, the Extinction Rebellion and Just Stop Oil are not, they're not legislatively proving that they can or can't do what they're doing. They're just going on and on about the campaign and the environment. Now, a few months ago, I was just talking about why they're doing that, and then the courts decided that they weren't going to let them talk about it anyway, right? But I was annoyed that they weren't actually just trying to prove that you can do what they were doing, right? Which it is arguable under the Town and Country Planning Act for models, representations in public. It's possible to argue it under there, under your acts and actions, where it falls under an advertisement for a campaign or not. It is possible to argue it under there, but they haven't been trying to argue it at all under that. And also in the Public Meetings Act as well. you know, and definitely when they're recording things. But, you know, so, you know, in a way, the Parliament really got rid of something that actually would. It's almost kind of like when they pulled the act, they know that there is proper rights, but then they've kind of left this. All these massive demonstrations and protests and so forth now are all uncertain who's covered and who isn't covered, and then the police are just coming at it like like, you know, belly flopping a swimming pool from a top diving board and getting a red belly because they're just like you know, they're kind of like it's just, you know. So I don't know why they pulled that act. Well, why didn't they make some other changes to it? I think, you know, the thing about that procedure before, it definitely would have had you confirmed, and you wouldn't have had any disputes with the police or CPS then. For sure, I would have used it, and I wouldn't have been in the situation that I'm in now. Because when that person told me about petitioning, oh, why did you do petition? I didn't even know what it was at the time. And then suddenly, like, I got right interested in it, and I want to learn everything about it. If it had been 1984, right, or 1983 or 1980, when they said that, although I don't have the internet, but I've gone to libraries or whatever, then I would have probably used it. And then I wouldn't have actually run into the problems that I got now, because I would have been confirmed. So, and I wouldn't have had the idiot judge who didn't have a clue what he was talking about, you know? So that's the difference. So in a way, if you're going to take away that act and your proper official, well, it's meant to be official. It's meant to be official through Parliament, but the Petitions Committee in Parliament couldn't give a flying, swinging monkeys cockroach. They do not care. You know, they don't even care when you got 10,000 signatures. You know, sometimes they don't care if you've got 100,000 signatures, you know. Unless it's tampon tax, they're not bothered. So, you know, but yeah, it's a proper procedure. I don't know what the hell happened when they were doing committee of motions of griefs and petitions. So, and also, I think, you know, if they'd have still had that procedure, I'm starting to think that, you know, if you wanted to challenge the council on certain things, you know, like when you got the right of appeal for a resolution to either House of Parliament in law, what I've been arguing about for the Justice of the Peace Act 1997 and 2023, officially, you have a right for appeal for resolution. I think that you could have done that for the council, and you could have gone to a court, and then you said, like, you're officially appealing it to Parliament. And I think that court would have most definitely got the council's order suspended pending appeal. But back then, you see, 1986, before all these new websites and technology and emails so much, and Gordon Brown and Tony Blair's first petition site and all that, you didn't actually explicitly need 100,000 signatures, right? You know, just you could do petitions based on strength of evidence and get an action, but you could get lots of signatures. And I actually started to think that, you know, if it was something like development of a town centre or something like that, you could officially get recognised that, oh, I've got 100 people opposing this, and we're going to try to collect, 20,000 signatures, and then if that got put through a court, so okay, you can proceed to Parliament, then then the council, that's it. The council, that'd have been it. They would have like, the council, you're appealing it, the council would have had to wait, while you appealed it to Parliament. And you could have said, well, I want to collect, some signatures for it. Well, how many do you want? This is it. And that's what isn't happening now, I don't think. I'd love to know how many people from Oxford and Cambridge and, lawyers or other historians or anyone academically qualified is using the paper petition process to right into the Lords or right into Parliament with a eloquently set out letter, sending in loads of evidence without necessarily loads of signatures on this or that. But then again, I mean, probably only as many as how many McDonald's executives or Burger King executives, on £100,000 a year or whatever, are getting their lawyers to submit bills and lobby the government just based on the power of money, So, either way. But, and there's something... There's another thing in... What was I going to... It just came into my mind then, what I read in these screenshots from it. There was that... They said that, people need to be able to just decide that they're going to respond. Oh, yeah, if an incident happens and, exercise and invoke your rights to act, he said, to act and intervene, So... They didn't want to take that right away. But also for, if it's over 20 people. So, but what was that other point now that one of them said? Just trying to think. Just came into my mind while I was talking, so I'll have to mention that. There was another point. I think we'll go through them now, actually. I've just decided that we're going to read them. I'm going to read them to you. I'll show you them. Another example is when residents feel strongly that something should be done immediately on their behalf. Therefore, the provisions in the bill could undermine important and basic democratic rights. Well, we're not talking... It's not even... particular legal rights like, powers of arrest, but definitely democratic rights, political rights. So, I don't know what situation he's got when more than 20 people might need to do that, but I mean, you could have any incident, but he's saying that you can use them anyway, so there's that. Government, through their law and order policies, they do not recognise the essential interaction between the state and civil society at all levels in society in the operation of the state. Nor do they recognise that extra parliamentary democracy or direct democracy in as much part of our lives as the politics or representational democracy that we see here in Parliament. Therefore, when we start the process of enacting legislation, well, that's obviously referring to if you want to propose some yourself as well, as we are doing tonight, which affects the rights of individuals or groups to express their grievances. You'd be lucky now, because Parliament Petitions Committee don't think that you can petition them about grievances, only a change in law. And it's a miracle that I got mine through for a public inquiry. To express their grievances, we must realise that legislation has an important effect upon the whole of our democratic process. We must recognise that the form of legislation with which we are dealing arises out of the government's failure in other areas of the policies. We're controlled by government through their law and policies. Don't recognise essentially. So he was saying basically. I mean, one of them is like just blaming the government generally for just poor government, like poor laws, and just like that it's the government's fault if anyone has to protest, because the fact they need to protest shows failures in other areas that are clearly not working, which was. With my case, corrupt and legal practices in the council and the police, Reference also being made to problems caused alarm, harassment, and distress. So the bill's purpose is to prevent the disruption of the life of the community. One of the bill's purposes is to prevent the disruption of the life of the community. Well, that's quite a joke, particularly when the programme Alvida's Aim Pet was on at the time and everyone was going abroad to build houses like in, Mallorca or wherever. And now we're actually getting the peace broken by councils. Councils are actually breaking the peace and causing rifts in the community by destroying communities and areas, by literally pouring concrete in between everywhere, and blocking off everyone's views. Turning every village and town into a city, whether we like it or not. And then they go bankrupt, and then they sell it to the Chinese. As a direct result of the activities of the campaign for nuclear disarmament and Cruise Watch in my constituency, there has been a massive closure of traditional rights of way across Salisbury Plain. Local inhabitants have been thus deprived of the age-old and traditional rights which they have enjoyed, despite the fact that Salisbury Plain has been an important military training area, the intervention resources. Why does there need to be any military action at all anywhere near Salisbury Plain? It's like one of those stories like, James Sainsbury comes out with of Sisbury Ring Hill Fort and Shanktonbury Ring, where they were ravaging it with tanks for training, further excuses to tear up some more of the historic evidence of the past, more bones, more evidence destroyed, more evidence, more prehistoric ancestry and evidence ravaged by the victories of the conquest, tear some more of it up, burn down, burn some more House of Commons records in Parliament, build on some more ancient sites, and wheel spin some more tanks on Sisbury Ring Hill Fort, tunnel a hole through Stonehenge, underground, destroy the earth energies. We need to put us, they're even acknowledging this on the Public Order Act. Stonehenge and Salisbury Plain is a topic of discussion, and I know they've always been trying to further and further and further encroach on rights there and disrupt the atmosphere. The peaceful atmosphere and energies must be observed by large numbers of police officers and so forth, as if somehow it could be a vibrational place of love and freedom and caring, and that might have an effect on, corporate business elites who are only interested in profit and making money out of people, and detrimental health effects, Official report. It's referring to a report here. The bill is a response which has been developing over many years and welcome in the community which faces these problems in rural Wiltshire, as much as debate in recent editorial Salisbury Plain and Muddle and the Stearns. Stonehenge Festival will complete its the Stonehenge Festival, this isn't in 1986, will complete its transformation from a crowd of scruffy dope smokers making a nuisance of themselves into a Wiltshire field to a major civil rights issue. He said the way of avoiding this was to allow the National Trust and English Heritage to have controlled festival on the site, and that the requiring of a swallowing of pride and the recognition of thousands of young people don't want there to be. So, I think there's a famous story about someone finding a petition on the Salisbury Plain, and someone, the mayor thought that it should be delivered to Parliament, and then Parliament thought nothing better to burn it, right? That's an old story. I think that story is like possibly from the 1700s or 1800s. You can look that story up. It's a legitimate story. It's well cited, and it often comes up on history websites that someone found a petition on Salisbury Plain, and they found nothing better to do with it once it got to Parliament than chuck it in the fire and burn it. Maybe if that was from the 1700s. I'll have to check up on that because I can't remember. I think it's from something like the 17th century, right? I think it might be from the 17-something, that story. If it is, and if that story is a well-known and cited story around historians, and generally, that even could have possibly also contributed towards that, Parliament burning and the spark, the idea behind that. Nothing to do better with these petitions than set them on fire, burn them. Added into the whole Bow Street Runners and the forming of the Met Police and Sir Robert Peel and, William, and the whole rest of the, there are lots of issues around that, the forming of the police force and common informers. A lot of people were engaging in police work themselves. You see, one of the major parts of the fundamental rights is the right to enforce the law and bring a case yourself and use policing. Really, that is the main basis behind the right to petition all the way through anyway, under assisting offenders. There's no doubt about it. But you can't really use that when it's just like a large amount of people are complaining about Julian Assange or wanting to get the law for tampons changed, because what are you going to investigate? Unless you're going to claim like Roger Hallam going to a supermarket and start handing food out to everyone, you're pushing it if you've got a large group of, 100 women who want tampon tax changing, or the quality of tampons improving, so therefore they go into a supermarket and just help themselves to a lot of tampons and proceed to test them out, to quality test them, and then send the review into government on quality control. You're pushing it then, but this is the thing. If you were going to a court, if you had, 20 women, and you said, we want to get the tampon tax changed, we need to, maybe they want a subpoena, maybe they need evidence, maybe they have to say to the court that they want to, maybe they, I don't know. What happens in these courts? I don't know. What happens if you've got a proceeding with 20 women and they want to get more supporters and they're wanting a petition to be approved by a court to be able to be put to the House of Commons to be approved to go to the House of Commons along with all their actions, and they wanted to start tampons? What happens? Well, maybe they might have to buy their own. What if they haven't got any money? What if they can't afford it? What happens if they say, well, they want to requisite some for testing? Is it a civil case? If they win, can they claim the money back from Parliament after? This is the thing. I'm not sure. There's police requiring to use a pen to write down a statement, and there's, women requiring tampons for evidence of quality control. Two different things. If they don't have any, I don't know. Can they acquire them? maybe they should get some donated. I don't know. Maybe the company might actually approach the company and say, look, can you give us some free ones to test out or something like that? It's worth a try. It beats covering the place in red paint anyway, doesn't it? Stonehenge Festival. So, Stonehenge has had an issue the whole way through. Some of them are regarding them as hippies and dope smokers who need to be quelled. And now they want to drill a tunnel through the floor. One of the key problems of public order is that rights or people protest assembly, which together with freedom of speech form the basis of the right of political dissent, exist under current law only in the negative sense. There is, for example, no defined legal right to demonstrate or to attend a meeting. Well, they got the public meeting. Just a minute. Whoa. Just a minute. One of the key problems for public order is that the rights of people, peaceful protest and assembly, which together with freedom of speech form the basis of the right of political dissent, exist under the current law only in the negative sense. There is, for example, no defined legal right to demonstrate or attend a meeting. Yet those freedoms are a crucial part of the relationship. Can you believe this? This is absolute and complete tosh. This is 1986 under Margaret Thatcher's government. Who is this man? This is Hansard. This is like George Galloway was in Parliament the other day, and I think Mark Franchois called him out and said, I didn't say that. Mark Franchois calls out Galloway the other day, and he's like, I didn't say that. He claims that Galloway's claiming he said something that he didn't. Andrew Bridgen ought to take note of this, right? I'll have to send this to Bridgen, although I don't know whether he listened to it or not. Bridgen, right? Why is there a Public Meetings Act which is actually even included now, even though it's repealed, it's been put into the Representation of the People Act and also into I think it's in one of the Public Order Acts. I think they might have ended up putting something about this into it as well, but there was already an act. There was a Public Meetings Act and in Representation of the People. And it's illegal to break up an official proper public meeting and stop people giving evidence in it. So he's actually wrong in this. And I know off the top of my head that I think it also, there's something inserted into one of the Public Order Acts as well. But before then, you actually had the Public Meeting Act and it went into the Representation of the People Act. He's talking tosh here. Look at this. Look at this. Can you believe this? Look at this right here. There is, for example, no defined legal right to demonstrate or attend a meeting. Bollock! Absolute tosh. This is in Hansard of the Parliament of England. Right here, people talking absolute, complete tosh. Complete tosh. Complete and utter, total tosh. That's a lie right there. That is, if that was a court, that is contempt of court. Right? Right there. That is contempt of court. The Houses of Parliament are actually a judicial authority, like a court. Right? This is a complaint to the Judicial Conduct Investigation Office that actually has jurisdiction over Parliament through Constitutional Reform Act, representations with the House of Commons. This guy might be still alive, one of these. Most of them have popped it now, and I haven't recorded the bottom of the screen further down by whose comment this is, but I can find it. This guy, he might still be alive. He could be prosecuted for this. Oh, only in cognizance of Parliament. Well, this is the Judicial Conduct Investigations Office. Where's the Privileges Committee? This guy could be, this guy should be prosecuted for contempt of Parliament. This is lying. This is not like Mark Franchois saying, I didn't say that to Galloway. This is perverting the course of justice. He makes a claim. He claims that there's no legal definition in law for a right to attend a meeting. When there's a public meeting, there's an actual Public Meetings Act. Has this guy just been enrolled into Parliament? Has he just been elected like 3 weeks before? By 30,000 votes or less in, Market Harbour or somewhere. These people, right? This is the problem with the Old Bailey in the William Penn and William Mead case. Although even then, they said, "Oh yeah, we've got rights, so we know what they are, but you're not having them. We're not giving you them. We'll slit your ears off. Cut your throats." Threatening them, never mind threatening and menacing behaviour in public. This is like the judiciary threatening people. Look at this. How can you can't have people like this put in legislation. This got put through. This act, this Public Order Act 1986, this has got Patel written all over it. like a gooseberry tart, this. This has got paper towel session written all over it. Tosh, tosh, absolute, complete and total tosh. In Parliament, in recorded writing. You know, I'm starting to think now, if I can just get something that I'm bothered about, right, that I'm concerned about, right, and, you know, I have to do it because, you know, I've got important stuff to do with me, not only other people, and then I end up having to go through this stuff and read it, right, because I need to, because I'm trying to prove a right exists, right, and I want to find out what happened to, you know, the petitioning procedures for evidence, and I'm having to go through these Parliament Hansard conversations, and we're finding Muppets, if they can be bothered turning up. You see, now when you watch Parliament on TV, there's nobody there except George Galloway. You know, he says more on his TV programme than he does in Parliament, except when Matt Franchise tells him that he's talking tosh. You know, this is the problem. We've got people, right, who have got these titles like Right Honourable, Baron McKay of Cashfern, a lawyer, Baron Wakeham, Chief Whip, the Lord Havers, the Attorney General. Probably got something to do with this. I would have thought so if they're repealing the Tumultuous Petitioning Act. And then the second Viscount, Hailsham of Marylebone, Quintin McGarrel, Hogg, Baron Hailsham of Marylebone, the Lord Chancellor. And we've got tosh. No wonder the Americans are coming out with, like, the Dukes of Hazzard County. You know, just the good old boys, never meaning no harm, except if they weren't talking absolute, complete and utter, pure tosh in Parliament, written down, recorded in Hansard, which constitutes as a criminal offence, a corrupt and illegal practice, giving a false account and false evidence about the law and what law does or does not actually exist, and even what definitions can be defined in law. How can we even begin to define the political rights that do exist, which are written down, when these people are making changes to law and they seem oblivious to him existing, unless he was lying? The Public Meetings Act also actually, I think, is connected to the Public Order Act as well. I think it's definitely in the Representation of the People Act for the political part of it, right? So I don't know why he's saying this. He knows there's a Public Meeting Act. There's a specific act for public meetings, right? And the exact provisions from that act were kept and carried over into Representation of the People, right? So why, you know, what is happening here? I'm trying to find evidence of the Tumultuous Petitioning Act. I also find in that act, in the repeal section, which I indicated in the previous video, that they are lying about the section on which offences withdrawn. So it seems to me that I'm finding it very hard to find out what this legal proceeding is, which exists if you've got over 20 people. Where is it? Dr. Brodie Waddle, who doesn't have time to listen to me, because he's a very, 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 very busy Canadian immigrant in England, who's now got a doctorate in history research. You know, if Dr. Brodie Waddle doesn't have time to speak to me after he's been, you know, kindly transcribing all of the petition evidence, who does? You know, this is it. I mean, it's literally like Dr. No, isn't it? When when he goes into, you know, the geology lab to see the professor, Hello, Professor. I'm sorry I could waste some more of your valuable time. Can you tell me something about these rock samples? Well, they're just normal. Well, Can I see the receipt? Oh, no, he threw it away. Can I see the petition? Can I see the tumultuous proceeding evidence? Can I see the evidence of the tumultuous proceedings, Professor? No, they threw them away. I've asked John Burkow. Professor Burkow, can you tell me where the tumultuous proceedings evidence are for over 20 people? I'd like to see them. Oh, no, they threw them away. Where are they? Oh, they burned down in the fire. They burned down in the fire. Well, along with that one from Salisbury Plain that they threw in the fire. And who started the fire, Professor? I don't know. Was it Sir Robert Peel? Did he tell the clerk to start the fire? This is it. It's like being in Dr. No, this, isn't it? But then we've got important people with important titles who are, yes, you're right and honourable. That's all you hear from these people. If you type, in fact, if you type in the right honourable in this, it turns up more times than the word rights, and I'm quite sure when you type in the word right, it's not a part of right and honourable. We've got problems because what's happening now, while I'm investigating illegal road signage using rights, and then I get unlawfully prosecuted, and then I have to prove that we have got rights. Now, what I'm finding is not only the illegal road signage, not only that, another corrupt and legal practices, which is what I was happy enough doing that. Now we're on making the law. Right? And, probably illegal prosecutions for matters that are cognisable, debatable, only in Parliament. Well, lucky that we've got the Constitutional Reform Act Section 5, which is representations to the House of Commons. Now we can make complaints about such cognizance decisions in there, particularly when it's through the Judicial Conduct Investigations Office or even the Privileges Committee. Right? We're all getting people are getting annoyed with AI. That the phone's listening to you all the time, or the phone's looking at what you're looking at, or looking at what you're saying, and using AI and calculating something. If I'll tell you what, right? If you got a judicial fact-checking computer, right, which had half the intelligence that I've got, right? I'm not claiming that I'm Gail Bradbrook or some professor in microbiology, right? I don't need to be Dr. Brodie Waddle, right? If you programmed an AI cop, an AI detective, right, to go through Hansard, you would be quite alarmed at the findings, because I'm quite certain that if you actually used an AI program to go through Hansard, you would end up with at least, they're stepping down all the time, these MPs, but is that good enough? You would end up with, you could probably fill Belmarsh up. Never mind having Julian Assange in Belmarsh. You could probably fill Belmarsh up with MPs, right, who have been doing corrupt and legal practices if you get the right impeachment process discovered, This is the problem. Or are they going to use the AI to comb through Hansard to remove the glitches and mistakes before anyone knows? This is the thing. This is not good enough. And it makes you wonder, what is Rishi Sunak doing? What is Priti Patel doing? What? And this is the thing about the Petitions Committee. Cat Smith, MP, Labour, right? I am having to complain about lack of enforcement, lack of petition support, lack of use of powers of committee to assist in casework. We've got 38 degrees perverting the course of justice, stealing evidence in casework, denying the right to petition. All people have the right to petition, so how could they deny you access to use their website if it's for petitioning? Because no one can be denied use of it, right? That's breach of freedom and liberties. Websites that are claiming to be helping people, but they're not. They're actually nearly as bad as these MPs. If we could actually get someone to do something right and obey the law, it would be something, This is the problem now. In fact, I've already complained to Big Brother Watch about, those special procedures we've found in election petitions rules, corrupting legal practices. The Big Brother Watch, right, are meant to be working with the House of Lords, right? That's Silky Carlo. This right here, the Big Brother Watch, right, have got connections to Parliament and the House of Lords, right, and they are actually meant to be getting some pro bono now. They need to be pro bono in Parliament. I know that people are calling MPs out all the time. People are calling, Boris a liar, and he's getting a lot of flack, but only after a certain amount of public. Only because, everyone's complaining. This right here, this is worse than Johnson. This is worse than Boris, because at least with Boris, it's like joke. It's like stupid party. It's like a stupid lockdown party, stupid pandemic thing. Oh, I don't know who's at a party. Oh, how can you not know you're at a party when you're at a party? This is like stupid people. But here, right here, this makes Johnson, right, look like some kind of, tuck shop, Grange Hill Tucker kind of, tuck shop joke. This is like pure, unadulterated lies. Complete and total lies, written down in Hansard, recorded in Hansard, right there. There is, for example, no defined legal right to demonstrate or attend a meeting. Absolute tosh. There's an entire act on it. A specific act that was made for that purpose. An act that has only got 1 or 2 pages to it. In fact, it has one point and purpose: to make sure that people can't break a meeting up or prevent people from transacting information to each other in such a meeting, right? So why say that? What else do you need to do? What can you do? This is like local councils as well. We've got Colchester Council Watch, right? They are now got their eyes on local councils and more of them, and they're watching and scrutinising them, and there is some antics. One of the council chairmen comes out with, someone asked him what legislation the council runs on. He said, it's a philosophical question. No, it's not a philosophical question. It's never seen a philosophical question. What does it mean to be happy? What is the meaning of a flower? No, I asked you a factual question of the legislation of which the council is running on. We don't seem to have the staff. But then we've got Mark Rowley, right, running an entire police force of London, right? And he is the same. It's the same with Max Hill, right? Leading the Crown Prosecution Service, leading the CPS, in charge of it. You've either got to have 2 big balls, or the problem with a lot of these people is the lack of awareness gives them the courage to go forward, right? If you are not very self-aware, and if you don't know the dangers out there, you are the braver the man to walk into the unknown. If you are too scared and too self-aware that you might be making mistakes, then you just can't do it. Because then, but these people, you can't, balls are an excuse. you can't say, oh, someone's got to do it, so bear the man with the balls who is a complete compulsive liar. We don't want people with the balls who are complete compulsive liars to do it in Parliament. Same with Charles trying to take away our rights, even though the Act of Settlement 1700 says that he can. He's knocking around with the WEF and the WHO, popping up repping. I'm just doing a bit of repping. So what are you repping for the new policies they're putting through, Charles? Been talking about that in the meetings. But you can't do it. This is the thing. Even the king as well, breaking the law, the 1700 Act of Settlement, failing to preserve and protect our rights. The rights don't need much preserving and protecting when we've got people in Hansard who are meant to be elected MPs who seem to be oblivious of them or in complete denial and lying, do I need magnifying glass? Let's read this again. There is, for example, no defined legal right to demonstrate or attend a meeting. Absolute tosh. A specific act of law which specifically, explicitly is made to ensure that people have got the right to have meetings without intervention or removal or without preventing the transaction of information, which is what's happening with YouTube. This is what's happening with YouTube now, when YouTube are claiming, we've got policy. Tosh. We're meeting on there. And it's even difficult to persuade Robert F. Kennedy Jr. with his section 20 whatever, with his publication section or whatever, which has got nothing to do with us and our interactions. That's purely to do with being treated as another party in a claim. But that's got absolutely nothing to do with what rights you've got under the legislation of the country and that apply to the platform. It's to do with who's party A and who's party B and who's to be treated as what party. Got nothing to do with what party that you actually are being treated as, what are your rights, and as a platform, when they are acting, what rights, what can they and can they not do as citizens, as business owners. It's got nothing to do with who they will be treated with, whether they're treated as Warner Brothers or not Warner Brothers, or part of Warner Brothers or not. It's got nothing to do with anything like that. It's to do with what can and can't they do as anyone else, I'm going to move on now to the next part. Living things properly updated and continues, no guarantee. Sorry, living things is properly updated and continues to guarantee the rule of law under which the majority of our people will wish to live and which protects their rights. I support the bill. So he's saying that, in this part, he's saying that, other people who are going about their business need their rights protecting. But usually people who are using democratic rights only intervene because it's a matter of utmost urgency or importance, just like the police, it's really on the level with... It is comparable and on the level with policing, obviously, unless it gets to larger numbers of people. But then again, so why did they pull the Tumultuous Act? I'm starting to think that act was a good thing because it was before 1688, and what it did is the thing that I now like about that act is that it actually officially acknowledged and recognised that what you were doing not only was official, but it was legal, a legal engagement and a legal process, not just some kind of... I don't know how it's regarded now on House of Commons. It's regarded as because even if you get 100,000 signatures, and Tess Lowry did well to get that debate, and it's all on video and it's all official, and you might even get called in to give evidence, or call yourself in to give evidence, like I just gave it anyway. It's to say that. Well, I think Tess Lowry gave extra evidence to what was just written in it, but other people want to read it on there. They don't want to have to wait to the debate. Or if they want to know more about it, sign it. First person disorder we see. Members who have called for a right to apply to the county court judge, would want to have the meeting or procession. I join those honourable members who have called for a right to apply to the county court judge in the local summary civil court for a review of the merits of the decision to prohibit a meeting or impose conditions. So I wonder if that's definitely got something to do with in and around. We're getting onto the area of that pre-tumultuous period. He's saying a right to apply to the county court judge, but there's not 3 justices or a grand jury in that, though, is there? In the local summary civil court for a review of the merits of the decision to prohibit a meeting or impose conditions. Certainly, a summary procedure is required to enable a review on the merits of a meeting to take place. I wonder if it was regarded. I wonder if it was regarded as a civil summary proceeding. But if so, what about if the part of the Tumultuous Act was still in place, where it had to be 3 justices or a larger part of a grand jury? That certainly, I don't think, was amended or repealed at that time. And this only says 1 judge. So maybe he's. I think that he's touching on the subject with that. I think he's kind of like he's putting some suggestions out there for potentially what. I shall make some final brief points and effort to at least in the Conservative and Land member participate welcome provisions part 2, which deals with racial matters. So that could be something there. This is as close as I have yet got to it, because I don't think the actual petitions that Dr. Brodie Wells translated, I don't think they're going to say too much about the actual. They're just the actual petition itself. They're not like that. The William Mead and William Penn case, where it's like it's got like the full proceedings and full dialogue, everything. It's like it just basically like it sheds the entire light on the proceedings and what's happening. It's great to see like all the participants as well. Like there's mayor, then the alderman, there's like 2 sheriffs, the recorder is basically like almost what we would, I guess, what we would be regarded as a legal advisor. The recorder is kind of like almost like running the proceedings, and the mayor doesn't really say too much. I don't know how you can act like a legal advisor and record all the thing at the same time, but he was doing it. not do anything to protect. Well, it may do a great deal for the false beard and moustache industry, but it will not do anything to protect us as it was intended to do. The sanction is imposed at the wrong time. Those who have been excluded but break the exclusion order and go to football match. We've got one of the participants is this Mr. Nicholas Lyle, Mid Bedfordshire. Actually, Lyle is one of the idiots in this saga. I remember his name now. So this Nicholas Lyle from Mid Bedfordshire, he's one of the Muppets. Although I'm not too sure if I can attribute him to that blatant lie about public meeting law and rights. But what I can say is that, that Nicholas Lyle, he's one of the guys who is not really one of the greatest savoury characters out of this whole saga. They don't want to decide where a demonstration should take place, which route it should do. If we decide to go along that road so that those who are prevented from carrying out their democratic rights can complain to elected representatives, such decisions should not be made by the police. Right. That's the bit that I'd forgot earlier. Earlier on, there was something that I was trying to remember that popped into my mind, and then I said, something's popped into my mind and I need to mention it, and then I've forgotten it by the time I'd finished. This is it. That's it there. So, what he's saying is, if people are going about protests and so forth, but if they were to make legislation so the police closed roads or had powers to close roads or prevent people from doing certain things, what would happen if people were actually... He's actually acknowledging now that, there is a right that exists that people might be using, democratic rights that, clearly the police would not be able to prevent them from, pursuing whatever they were pursuing, even if the police had closed the road off or claimed to or so what. Which raises the question for Insulate Britain and those injunctions and so forth, Are they really valid on people who are genuinely using right to the full effect? But anyway, so that those who are prevented from carrying out their democratic rights can complain to elected representatives. Such decisions should not be made by the police. Right. So they're saying that if there were certain powers or if certain things have been done by an authority, then people can complain to their local councillor or MP and get some sort of action against it. Either, I don't know whether that would be through the courts or council or for themselves, but if you've got a right that applies to you, then surely that right applies. Now, whether or not you would get your MP to step in or your councillor, you'd have a fat chance nowadays when they're all Labour or Tory and opposed to independent people. I think the Lib Dems in Bath, they wouldn't even let some people use some of the rooms for a meeting. They prevented them from doing it or they didn't support the cause. They thought it was too extreme. I don't know how well that would go down the Public Meetings Act or the Representation of the People Act, with which it's been put into and so forth. I think that's not lawful. You see, that there are plenty of people on councils who don't know the law. So that is the other. So, there's some reference here to actually being able to complain to an elected representative. So they don't think that the police should be making certain decisions over our democratic rights. You can complain to your MP. Well, if your MP, if it's a matter for Parliament that you're acting in, and your MP is your elected representative, then they're meant to represent you in your interactions with Parliament, not just the Petitions Committee. Your actual local MPs are meant to be your main connection to the Petitions Committee. If you just, didn't have the internet or post, like in the local area. You know, they're meant to be a first point of contact. So your local MP's meant to act with the authority of Parliament, you know. So for sure they're meant to validate your political rights and so forth. But this comes back to the whole thing, you know, with if your petition, you know, like if it was under 20 signatures, you don't need to use that tumultuous procedure, then it can go straight to Parliament anyway. So you could give it to your MP. In that tumultuous act, it's talking about handing it to your MP. But you didn't always have MPs, depending on if there was or was not a Parliament called, because they didn't always have parliaments, you know, or sometimes Parliament wasn't sitting, you know. Although after 1640s, you know, you had longer and more permanent parliaments. So that's the other bit that I wanted to I don't, you know, so it's interesting. The thing with the Tumultuous Act is it's a connection between the court and the council, or the court and Parliament, that they don't seem to want to use or have anymore. You know, unless it's council tax, and then the council are renting out a court to make you pay money that you owe the court, right? The ironic thing with the Tumultuous Act is that you are wanting to do something to political, legal case, but it's to Parliament, and you have to go through a court first. So, you know, it's like representation, Constitutional Reform Act, Section 5, representation to the House of Commons. There is an avenue there straight away, you know, right there. But when it comes, I think the council do call the police. They start to call the police when people turn up at council meetings and are a bit rowdy, or they produce a bill whose overall effect is to undermine democratic rights while pretending that they are dealing with racism when in fact they are not. My honourable friend, the member for Leighton, Mr. Cohen, raised an important argument when he said that the government should do far more to deal with racism. The government are attacking basic democratic rights, dragging the police into the political arena, and ignoring the very probable that have been, the very problem. I don't know why that thing on the right-hand side is covering some of the words that with the yellow lines on, because that's when I was searching a document. Government were attacking basic democratic rights, dragging the police into the political arena, and ignoring the very problems that have been the focus for the bill. Until there is some understanding of the socialist principle of more equality between the distribution of wealth and power, the riots that have broken out in our streets will continue to distort the fabric of our society. Wow! Now, this really is a piece of record from Hansard as opposed to the previous, which was complete tosh. Now, this guy here, I hope it's not the same guy, actually. I didn't screenshot who it was, but he's saying the government are attacking basic democratic rights, dragging the police into the political arena, and ignoring the very problems that have been the focus for the bill. Until there is some understanding of the socialist principle of more equality between the distribution of wealth and power, the riots that broke out on our streets will continue to distort the fabric of our society. Now that should be framed, that should be framed in a plaque and put on the House of Commons wall. I mean, that is something that you'd have thought Jeremy Corbyn had come out with. I mean, if you look at this, the government are attacking basic democratic rights, dragging the police into the political arena and ignoring the very problems that have been the focus of the bill, until there is some understanding of the socialist principle of more equality between the distribution of wealth and power. Sunak could learn something from that for sure. The riots that have broke out on the streets will continue to distort the fabric of society. Look at this, calling out for a socialist resolution to the inequality between the distribution of wealth and power. Sorry, the equity, more equity between the distribution of wealth and power. Same thing. So equality. So wealth and power. Wealth and power. The distribution of wealth and power. I mean, you know, in the Thatcher government as well. I mean, that should be on a plaque in number 10 Downing Street. In fact, I'm, you know, if I get my tax return that I've applied for from Jim Hara, right? If Jim Hara sends me the money that I'm claiming for my tax VAT refunds over the last 10 years, which I don't exactly know how much it is, but I've put a best guess in, right? I'm basing it on an estimate, right? For this campaign, right? I will get that on a golden plaque on wood, right? And I'll send it to John Bercow and I'll let him present it to Sunak, right, at number 10 as a present, and see what Sunak says to that, you know, or even Priti Patel as well for a Public Order Act 2023. The government are attacking basic democratic rights, dragging the police into the political arena and ignoring the very problems that have been the focus of the bill, until there is some understanding of the socialist principle of more equity between the distribution of wealth and power. The riots that have broke out on the streets will continue to distort the fabric of our society. Bang right on the front of number 10. You know, it beats Extinction Rebellion climbing on Sunak's roof, doesn't it? I mean, that is better than Extinction Rebellion climbing on an oil rig and putting a banner up, or climbing on Sunak's holiday retreat in North Yorkshire, isn't it? That if you put that on a golden plaque and present it to the Speaker, you know, if George Galloway, right, had walked into Parliament to take his oath, right, and that girl, that clerk, would have held up that, you know, his oath to read out, and then he would have proceeded to walk up to the Speaker and pull that out on a plaque and said, "Here, stick this on the wall," right? That would have been something in history compared to, you know, the Old Bailey plaque with the right of the jurors on it, wouldn't it? You know. Now, you know, what an amazing excerpt from Hansard, you know. You've got that, literally, you know, this excerpt here, and then you've got the other guy who is talking absolute complete tosh, if it is him. I hope it's not the same guy, because then you really got a problem. You've got a personality disorder then, you know. This is literally priceless. You know, and under the Thatcher government as well, you know, there is, you know, it would be interesting if it was the same guy, but this is the difference, you know. Some of these people deserve putting in the House of Lords, or deserve awards, and others deserve, you know, going to Belmarsh, you know. It's got to beat Johnson holding up a frozen kipper as that, you know, or shearing a sheep, you know, or going and pulling a pint, you know. Seriously, that needs framing compared to the last, bit that I criticised. This is a bad bill, and who's this? Minister of State, Home Office, Mr. Giles Shaw. This is a bad bill. It might have been him, actually. This is a bad bill, and it represents a lost opportunity. So many things could have been done to codify properly common law offences. So much could have been done to improve the law in this area generally. The government have chosen to ignore the problem and to carry out an attack on the democratic rights of the people of this nation in a way that will undermine the rights of assembly and demonstration in a manner that we have not seen this century, and I include that in my comments on the 1936 Act. I don't know how he's figuring that in if you're actually going to call it a public meeting out in the street, because it can't be broke up, particularly if you're imparting information to each other. Some of them are kind of like, I don't think some of them are that savvy on it. Some of them are. This is why, there's a lot of rumness, as you refer to it in the House of Lords, a lot of rum fellows. There's too much, there's a lot of fireworks and, panache and showing off, but yet, when it comes to the actual logic and fact, a lot of the time, there's much to be, there's a lot lacking in this. Benjamin also said that there should be a statutory right to demonstrate. The bill will not affect. So he's saying the bill will not affect traditional rights to demonstrate peacefully and lawfully. Well, that's what it's usually supposed to be anyway. It is a basic assumption in public order law, as with other law, that people are free to do something unless there is a rule to the contrary. Well, what about as if there's a rule to the contrary against the prosecutor or the police or the judge? This is joke. This is kind of joke here, because this guy, right, is going, the bill will not affect traditional rights to demonstrate peaceably and lawfully. It's a basic assumption in public order law, as with other law, that people are free to do something unless there is a rule to the contrary. Well, who's the rule against? You're right to do something if you're a prosecutor, a judge, or a policeman, unless there is a rule to the contrary, which there happens to be under a certain enactment. If we provided a right to demonstrate or to march, and the presumption of law gives us the right to be undermined, the right of peaceful assembly is in any case guaranteed by the European Convention on Human Rights. Some of them have mentioned the Bill of Rights, though. One of them denied the Bill of Rights, though. One of them said there wasn't. One of them acknowledged the Bill of Rights, and another one denied it. My honourable friend, the member from Harlow, mentioned judicial rule as the presumption that the law gives other rights will be undermined. That the law gives other rights will be undermined. The right of peaceful assembly is in any case guaranteed by the European Convention on Human Rights. That's the same part. The unlearned member Montgomery again referred to a Bill of Rights. That is not part and parcel of the measure. So this is interesting. He's saying here, the honourable and learned member for Montgomery, again referred to a Bill of Rights. He says a Bill of Rights, not the Bill of Rights. That is not part and parcel of the measure. There are substantial arguments against proceeding along that line in a country that has not had a written constitution that he might quite understand why he seeks to ensure that these discussions on the bill will keep a close eye on various aspects that affect the liberty of the individual. Right. So here, unless I'm completely and totally retarded, right, it's looking like to me, and they're being coy about this, that he's saying that the learned member from Montgomery again referred to a Bill of Rights. He's saying that is not part and parcel of the measure. So is he claiming that, this bill doesn't affect if you are using the Bill of Rights enactment, is separate? Because then you must definitely, without question, definitely are, and there's no assumption that you aren't, right? Which could be difficult under the Tumultuous Petitioning Act's definitions of what is encompassed under that definition of terms. That is not part and parcel of the measure. There is he might be trying to make out that you don't need to protest in public, but that's these are remonstrations, aren't they? I think what I've sussed out is I've kind of decided that I think that what Extinction Rebellion are doing are remonstrations, which is acknowledged in the Tumultuous Act, and it's kind of like making a point about an existing political cause, whether it's religion, of state, or of public matters of concern, which you are pursuing to get some sort of action from the government in, but you are making it a remonstrance, a public point, a public action, a public representation. I'm pretty certain that a remonstrance in law, it falls under the Town and Country Planning Act 1991 definition of advertisement as a public representation. Remonstrances fall under that, and possibly a model, like models, signs, theatre, stuff like that. You see, that's what needs to be argued with Gail Bradbrook's case. Is it like they're filming it, they're making a production, and it's a performance, and it involves some action, some of which might break things, cause criminal damage. But in that act, you can use a right, an enactment, and also in Town and Country as well. So that's a legal argument that they're never arguing. They refuse to argue it. This is the thing with Extinction Rebellion. You must bang your head against the wall. I don't know why they just won't talk. They'll just go on like the environment, and human rights. It's like Jonathan M. Fuller reading his, newspaper word for word, letter for letter. I wish these people would go in there and move their mouths and say, I'm doing using the Town and Country Planning Act, doing a representation in public, and this is an advertisement. We are filming it and promoting it to the public, and we are required to some props for this in order to make the production, and we are using our rights to seize these public amenities, which are covered with insurance for third-party liability, and I cannot be prosecuted or imprisoned, and therefore, it's questionable, if the Department of Transport want a claim through civil court against you, it's not a prosecution, is it? Maybe it's a commitment to be ordered to pay the money, but at least it's not a prosecution. They've got insurance now. I don't think they had insurance in them days. Everything's covered by insurance, so why not use it? I'm not suggesting to go around smashing everything up, though. But I don't know whether this guy's trying to make out that, just, writing something and popping it in the postbox and sending it to Parliament doesn't touch on this. But the Tumultuous Act definitely touches on all this stuff. The Tumultuous Petitioning Act, and getting onto that case of William Penn and William Mead, definitely does touch upon all this stuff. So, it is part and parcel of it. So if he's saying that this is not part and parcel of the measure or the activities that could be brought in and around that measure, that is not part and parcel of the measure. There are substantial arguments against proceeding along that line in a country that has not had the written constitution that he might preferably understand, or why he seeks to ensure in the discussion on the bill he will keep a close eye on the various aspects that affect the liberty of the individual. Well, that's the thing. In the Tumultuous, when you were under 20 signatures, I know I keep bringing it up, but it's relevant because that's the whole point of why I'm looking at this, is that, you know, if it's under 20 signatures, you didn't have to have any courts keeping an eye on you, other than the fact that you are the informer. You know, you are informing Parliament anyway. You know, and that's the point. I think that's the point. You know, it's like not so common informer. It's the curious case of the not so common informer. Informing on himself and his own activities and actions, you know. Here is some evidence I gathered. Ludicrous that Extinction Rebellion are constantly informing on themselves and everything they do, you know. That's the difference now. That I don't think the police can wrap their head around. You know, you don't need to go out there and get evidence and apprehend people when they are telling everybody what they're doing. Mr. Sir Hammersmith. The Home Secretary will let me say this. I would admit that a correction should be made to that. That's what he could have said about the guy earlier on who was talking tosh. The courts would not have discretion to decide the scope of the inclusion or definition. Well, of course, ban offenders from all prescribed matches. Getting into. The Honourable Gentleman raised an issue in relation to compensation. All right, the gentleman. Look, they're talking about compensation here. The Right Honourable Gentleman raised an issue in relation to compensation. I advise him that, to the best of my knowledge and belief, clauses of the bill which refer to that matter make only marginal change to eligibility for compensation, bringing the test into line with the definition of riot in future. Claimants will have to show that damage was caused during rioting by a crowd of 12 persons or more, rather than by present minimum of 3. Government have not studied details of previous claims, but I believe that the majority of claimants who were compensated after the 91 riots will still be compensated under the provisions of the new bill, and no new prosecutions for riot will have to be brought and convictions obtained before compensation is claimed. So do you get apparently do you get compensation? There was a compensation scheme, but what about the insurance? If they're actually insured, then, you know, I don't want to use my insurance. Well, what's the point in having it? You know. Home Affairs, we also have tried to ensure the rights of the minority in relation to the peaceful protests and the expression of views and marches and assemblies, and to ensure that the rights of the majority are not overruled by a minority. So, you know, that is referring to strength in numbers, and that definitely acknowledges the Magna Carta and the right through lawful due process to be judged by the law of the land or by the opinion of the peers. Ironically, it's only a random selection of 12 people in a jury, not the entire town or city or county or country anyway, which is quite joke, really. We have also tried to ensure the rights of the minority in relation to the peaceful protest and expression of views and marches and assemblies, and to ensure that the rights of the majority are not overruled by a minority unless selected by a jury of 12 people in a court of law, all sworn in on oath, or a larger part of a grand jury, or Officer Dwibble when he's kicking a door down to chase a cat. Make sure that it does not infringe on the rights of an individual. That is why we are so keen to see that there is construction. Oh, it's Extinction Rebellion blocking a road off, or whatever. Or Just Stop Oil, or Insulate Britain sat across the road when they've got an injunction. Make sure that they don't go get a larger part of a grand jury to overrule it. Well, that's the thing, though, isn't it? That's the thing. If the Secretary of State for Transport or Transport for London are doing these, they're getting these injunctions against people, right? What happens if someone had have gone to what happens if they've got the tumultuous procedure and it's over 20 people, and they go to a court, and it's a large part of a grand jury, and they say, we're doing this action, we're getting 100 people now, and we want to do some actions as well in London and block off a few roads, to raise awareness. And what if the grand jury said, yeah, that's fine, yeah, go for it. Like Ian Bray. It's like Gregory Perrin sat there with a hammer, Or was it Gregory Perrin sat there? There's Gregory Perrins. Gregory. There's a larger part of a grand jury. Gregory, larger part. They're going to shut some roads off on London. Order. Perrins. Gregory. Close the road off, Gregory. No injunctions around here. Been ordered. Order. The larger part of a grand jury. This is it. No defence against a criminal charge there to have to panic about at the last minute. I suppose in an injunction, it's only an injunction. We have also tried to ensure the rights. Oh, that's sort of no. What's this? We are not talking about the removal of statutory rights. We are trying to ensure peaceable arrangements between those who want to protest and those who live in communities. But what about people who live in communities who want to peacefully protest about construction people who are encroaching into their peaceful communities, building things that they objected to and don't consent to being built there, but yet the council approved? And they didn't put notices up or signs, planning notices when required. We're getting to like TfL now, like Just Stop Oil are going to turn it up and just standing there so they can't install the cameras, Elizabeth Select Committee on Home Affairs, we have also tried to ensure the rights of... Oh, I've read that. We are not talking about the removal from people. I think that's it now. I've gone through them all. So there's a few points there. It does... So that act was... That 1986 act is relevant. We're kind of like, that's probably, I don't know if you can get any closer to the subject than that. I think that's probably about as close as they want to openly talk about it without being too obvious, because I don't really think they like talking about it anyway as it is. There's a couple of, I found some serious questionable material in that Hansard that is what I think is just either incompetence, unprofessionalism, or just blatant lie. But there's also some good stuff in there as well. So, it would be interesting to read the Hansard for the Town and Country Planning Act 2007, probably, but I don't want to. I don't really need. I'm not. I don't have any questions about the act. I don't really have any. I don't need to ask any questions about the act. There are none to be asked. It's. It still doesn't solve the mystery of three justices or a large part of a grand jury, but I'm now got the. It's raised up the possibility of some civil summary county court procedure. Maybe that's what they were doing or had. I don't know. Or judicially reviewy sort of thing. I'm not sure. It still hasn't revealed three justices on popped up or a large part of a grand jury, but we're getting close. And some of them have alluded to the fact that if you are going about something proper, that all of this likely doesn't apply, and you can approach your MP to get confirmation if you're lucky. If you don't have a crooked Tory or Labour MP who is not opposed to your cause and who has got a clue what they're talking about when it comes to the law, which a lot of them don't, particularly if it's not Cat Smith, chairman of the Petitions Committee, on going by their standards. Standards! Yes, Cat, standards. Like standards that don't exist in law, that are based on no legal legislation or point, or standing order, or statute. Standards that you have just made up, Yet standards that come from previous standing orders from the 1800s that are talking about the eligibility of word and letter and signature on paper so you can read it. Like for people who couldn't write their name and had to put a cross on, or otherwise have agreed to subscribe or sign to the cause by other means, as nodding, raising their hand, or spitting on it, or, whatever. Everyone who agrees, say aye, or whatever procedures are set out in the Tumultuous Petition Act, which are consensual agreement. That's it, So, I'm wondering where to look now. There's got to be there aren't going to be any records if it's in a magistrates' court or maybe not summary county court either. If it's in a county court, in a summary county court, I don't think they have a recorder. Because I don't really know much about county courts. I've never been to one. If it was in the assizes, they have got a recorder. But why would you be going to the assizes? Why would you be in the Crown Court? Unless, but it's got it listed there. Someone must have gone in there. There's got to be some other records besides the ones that Dr. Brodie Waddle has squaddled. There's got to be some other, I'm talking 1920s, 1930s, 1940s, 1950s. People didn't really know much about it then because it's kind of it's a thing of the 1640s, isn't it? It's a thing of possibly 1700s, 1800s. It's not really a thing of the 1900s. It's not really like a done thing, or not like and I don't think that. I only think that it's because of the internet now why it's had a big resurgence. Even though that Parliament have got a website, I think it's Tony Blair. Even since Tony Blair did the first website, Obama as well. Obama with the White House. I think they did it because they wanted to be kind of cool and fashionable with politics, and they kind of raised it from the dead, but maybe to their detriment in a way, really. There's got to have been, I don't know who would have been interested in it all through the 1920s, 30s, 40s and 50s, but there were still some of those common informers knocking around. I think there was, in the I don't know they made common informing illegal, but I think there was some people still doing it, like in the 1920s or something, like people who were opening on a Sunday when they shouldn't have been and things like that. I think that it's that. I think that it's like the common informer, but it's not so common informer. In fact, I quite like the term not so common informer. I think that's the reason that music artist Snow does that informer. Musical Leo, get your boom boom down, because like I think he's referring to criminals maybe getting used as informers by the police, getting the assisting offenders, getting put on the assisting offenders. The common, if you are a common informer and you go to a court, even if you were doing it for that like reward money, you be on whatever you were doing to get your evidence, you would be under assisting offenders. But of your own volition, you wouldn't need Attorney General for it. That's for sure, because the Crown Prosecution Act bringing it, and what? Just a minute. The Crown Prosecution Service wasn't invented till 1986, so you didn't have all those procedures. The Crown Prosecution Service didn't have all that jargon, regulation, rules. Attorney General, blah blah blah. You just had prosecutors. You just had lawyers who were working as prosecutors. For the police or government, they had to turn up. You didn't have the Crown Prosecution Service as an established department. I'm not too sure exactly how the prosecutors operated and where they operated from. Or from the courts, or just from like a barrister's chamber, and they were rented out. They were on duty. So, I would have thought it was something like duty solicitor, but duty prosecutors and so forth. And they probably just liaisoned with police. I would have thought. So. Before that, surely those common informers, you don't have to get permission from the Attorney General, because you wouldn't have been able to bring the case, would you? It would have been interesting to know what the procedure was for that common informer, but that's only just to local courts. The not so common informer